The government sets the rates of attorneys who do Social Security disability. So you go to any lawyer, they're going to charge you the same thing. So you don't have to feel like you need to, kind of shop around for price. The most important thing in terms of hiring a lawyer is hire someone who's going to meet with you, initially, who's going to meet with you before you go to a hearing. A lot of times people will hire an attorney who's like in Texas because they get a number off of TV or in some way, and then the first time they meet with their lawyer is the day of the hearing. Well, that really is not helping you in the same way that someone who has really sat down with you and who really understands the ins and outs of your illness and how it's impacting you. The way lawyers get paid from Social Security is it's from what's called your back award, which you've been waiting to be paid, you've been waiting to be paid. You eventually win and you get a lump sum check for the period of time that you were wrongfully denied benefits. And for some people, not all, but for some people, it can really be a huge sum of money because of how long the process takes. Attorneys get paid out of that back award, and we're paid the smaller of one of two amounts, either $5,300 or 25%. And so if you're awarded, $50,000, your attorney, as your back award, your attorney would be paid $5,300. If you're awarded $1,000, your attorney would be paid $250. And that's what everyone charges, and that's what the government sets it as. So
you don't actually have to pay anything at all?
You don't? Yeah, the only thing that you pay, and some law firms do it differently than others. If you come to me and let's say you've been to 5 different doctors, and I get your file from Social Security, and it's before your hearing, and I see that Social Security, didn't even order your medical records from 3 of your most important doctors. Well, the best way you're going to win is if I order those records, and I'm going to order them. Your medical providers, like all medical providers, will charge me to copy them and mail them to me. But for most people, it's really too hard for them to, leave money up front to cover those costs. So at our firm, we just pay those costs. But at the end of your case, when hopefully you've won and you have money to pay them back, you pay them back. So it's not like you're just paying me back, reimbursing me for ordering medical records for you that ultimately would win your case. So, but in terms of if we lose, no, I don't get any money on your case. So, yeah. You don't. Well, actually, that's a very good question. You don't need to see a rheumatologist to be approved. If you go to your primary care physician and your primary care physician is treating you, and they can treat fibromyalgia as well as a rheumatologist, and if they believe that if it's their opinion that there's no way you can maintain full-time employment because of the severity of your symptoms, that's enough. They don't require a rheumatologist. So, yeah.
Is it from the time of diagnosis or from a year prior to the application that you would be paid?
Yeah, that's a great question. I have people come to me all the time who say, well, I was disabled in 1985. Can I get my benefits back to then? No. For supplemental security income, it's from the date of your application. For disability insurance benefits, you can go back a full year prior to your application. Yeah.
You talked about working full-time.
Yes.
What if you work part-time?
Great question. Yes, that's a great question. You can earn up to currently, for 2008, you can earn up to $940 a month gross and still be eligible for benefits. And so if you are earning $200 or $300 a month, $400 or $500 a month, you should really go ahead and apply. You are still eligible. Now, if you are earning, $935 a month, Social Security is probably going to say, well, if you're earning $935 a month, you could probably earn $1,000. But if you're making a few $100s here and there, definitely apply. Great question. Yeah, Beth.
I have found out that you can go back outside of that 5 and 10 year window if you can prove that you were disabled.
Mm-hmm.
At that point.
That's right. If you call Social Security and you haven't worked for 5 years and they tell you that because of that you were insured only through 2001, but you're able to show through your medical records that in fact you were disabled in 2001 and you are still disabled, then you're eligible. Now you can still only get benefits, at most a year prior to your application. But if you show you were disabled way back when, and that's the last time you were insured for, you'll still be eligible. That's a great point.
I stopped working in '93.
Yes.
And I can prove that I
Yes.
was disabled in '93.
Yes. I just had a client where I had to show that she was disabled as of March of 1994, but she'd been seeing the same doctor since 1994 over at Minor and James. And I called the doctor, and the doctor wrote a great letter for her, and we had all the medical records showing that she was in fact disabled. Because frankly, many people don't know that this program is out there. They don't know that, all the time the judges will be like, well, why did you wait so long to apply? And it's because no one told me that this help existed. Yeah.
I was disabled in 1997, so it's been 11 years. For a long period of time, up until about 6.5 years ago, I did not work. But because of the situation that happened with my now ex-husband, I had to go back to work.
Yeah.
And I have not been able to hold a steady current job
Yeah.
during that whole period up to now.
Yeah. That's a great point too. For a lot of people, they will have held, 3-month jobs, at the most 6-month jobs, maybe been at one place for a year, their whole career. And really, I find that actually helps your case if you've never really been able to hold down a job for it depends on your situation. Let me explain it this way. If someone has been working for 20 years at the same place and then suddenly leaves and can't work anymore, that person has great credibility going before a judge. Wow, they worked their whole lives. Even when they were completely sick, they kept going to work until they couldn't walk through that door anymore. That's a very compelling case and very sympathetic to a judge. By the same token, if someone because of their mental illness or because of a combination of mental and physical problems, maybe problems getting along with other people, whatever it is, has never been able to hold down a job for more than a few months here and there despite their best efforts, well, that too is really compelling evidence. That shows this person is out there, they've tried and tried again, but it's not working and it's really unlikely to work into the future. So, yeah.
Individuals who have put in an application and it gets lost, if that application could be accompanied by a postal receipt indicating, that it was received, et cetera, would that legally help their case to get reimbursement back to the first application that was lost?
Potentially. Yeah, potentially. It would depend. But if you send it certified mail, is that what you mean? And there was some, yeah, I think that would be helpful. Yeah.